I will introduce our speaker, who we are very pleased to have here today to give us the busy lawyer's guide to hearsay. And this is based on his federal evidence guide. So we have here Rene Valladares, and you all know from the past sessions that hopefully you've been watching that he is the author of a Defender's Guide to Federal Evidence. We will post that link for you all later on in the chat. But Mr. Valladares has been the federal public defender for the District of Nevada since 2011. He's an adjunct professor at the UNLV Boyd School of Law and a part-time instructor at the UNLV Criminal Justice Program. He lectures nationally on criminal law and criminal procedure issues, including conspiracy law, search and seizure, and the impact of culture on the criminal justice system. He also serves on the Federal Defenders Performance Management Group and the Federal Defenders Death Penalty Working Group. His publications include not just the book we just discussed, but co-editing the first edition of the treatise Cultural Factors in Criminal Defense, which is now in its 4th edition. So without further ado, I will turn it over to our excellent speaker. Thank you very much.
Well, thanks a lot, Vanessa, and it's great to go ahead and be with everybody. I'm going to go ahead and put up my PowerPoint, which I hope everybody can see. And again, thank you very much for joining me. I know that everybody is very busy, and I appreciate you taking the time to go over this important topic here. Now, like Vanessa mentioned, this has been a 4-part series, and the idea was to tackle 2 of the most challenging topics in evidence, and that is character evidence as well as hearsay. The first 2 presentations, the first two sessions had to do with character evidence, and today we're starting with hearsay. And I hope you can see me fine. It seems like all of a sudden things got a little bit darker in my screen of myself, but I do hope that you can still see me quite fine. Now, as I said, this presentation, as well as next one, is going to be on hearsay. I'll go ahead and break down what we're going to cover today, as well as next session in just a second. But just a couple of things. As Vanessa said, if anybody has any questions, don't hesitate. In addition to that, if you want to go ahead and reach out to me and after the presentation and just touch base dealing with a case or a question you may have, don't hesitate to do that. I'll go ahead and post my email in just a second here. So today, what we're going to go ahead and cover is basically the definition of what is hearsay. What is, at the end of the day, hearsay? We're going to talk about when something is not hearsay, and in addition to that, we're going to go ahead and cover hearsay exclusions, not the exceptions. The exceptions we're going to go ahead and talk about next time, but today we're going to go ahead and start with hearsay exclusions. Now, the format of the presentation, just like it was last time with character, the format basically will go ahead and follow the format in my book, the book that was mentioned so kindly by Vanessa, and that's the Defender's Guide to Federal Evidence. You can go ahead and buy it at the NACTO store online, and all royalties go to NACTO's Foundation for Criminal Justice and the great work they do. I'm very thankful for NACTO for allowing me to go ahead and do this, and in particular, very thankful to Vanessa for her time in making sure everything goes well with this presentation. But the presentation will follow the format of the book, that is the black letter first. Then we're going to go ahead and talk about cases, and primarily defense favorable cases. I have about 14 cases I want to cover. Only one of them is not a defense favorable case. That one is just a mere example, but otherwise, really the emphasis is on defense favorable cases. So, as I said, if you have any questions that you'd like to talk about after this presentation, or if you have any case that you want to go ahead and brainstorm, don't hesitate to go ahead and reach out to me. That is my email, and I do that frequently. I frequently, talk to people that have attended one of my presentations and that sort of thing. Now, hearsay. Why talk about hearsay? Because, hearsay, as we all know, has been, along with character evidence, one of the most misused, one of the most abused areas of evidence law by the prosecution. It is routinely abused all the way back to the Salem witch trials. And in those trials, of course, the amount of impermissible character evidence that came in, or impermissible hearsay evidence, as we know it now, of course, was really outrageous. And that is one of our main functions as defense lawyers, is trying to prevent all that garbage from coming in. But certainly it's good to remember about the abuses that have occurred in the past, that continue to occur every day in courtrooms in this country, that really should give us the impetus to make an effort to try to conquer character evidence as well as hearsay, despite the fact that they seem challenging. Now, let's talk about the approach we're going to be taking here in this series of lectures to hearsay. And basically, we're going to tackle hearsay by looking at 5 big baskets. And the first one is going to be, is there a statement under the rule? The principal thing we're going to be covering today is Federal Rule of Evidence 801. Now, if you're a state practitioner, don't worry. We are certainly going to be focusing on the federal rules of evidence, but a lot of this stuff is stuff that you will go ahead and see echoed in your state practice as well. So the first thing we're going to be looking at is there a statement? And to do that, we're going to focus on the definitions of Federal Rule of Evidence 801. The second one is going to be, is the statement offered for its truth? And this is one of the most misused areas by the prosecution. Prosecutors routinely misuse this area, and it's very easy for them to do it because oftentimes judges just hear, oh, it's not for the truth of the matter asserted, that way I don't have to do any thinking. Yeah, it comes in, and that's the end of things. The third part we're going to be covering today is going to be, is a statement not hearsay? Is it an exclusion under Rule 801? Now, for the next session, next Wednesday, we want to go ahead and cover the exceptions to the hearsay rule, both the exceptions under 803, which for which availability of the declarant is immaterial, as well as the exceptions under 804, for which the unavailability of the declarant is required. In addition, next session, we'll talk about how to impeach a hearsay declarant. The government puts on a hearsay testimony. How do we impeach that hearsay declarant? Perhaps that who may not be on the stand, who may not have been called as a witness. Lastly, for next session, we'll cover the intersection of the confrontation clause and hearsay. It is not going to be a full-blown discussion of the confrontation clause. That could be another session or a couple of sessions in and of itself, but certainly the intersection of confrontation clause and hearsay. Now, again, a lot of this stuff, seems intimidating and all that, and I, don't mean to in any way profess myself as being, especially gifted in any of this. I find it actually challenging. I have found that I needed to work at it. But, what I have found is that for my own usage, I've tried to develop a method to try to tackle this, and hopefully that may be beneficial to you as well. Now, so having said that, let's go ahead and start with our first topic here. And the way we're going to do it is that every time that I'm shifting to another big topic, another one of these 5 baskets, you will see this slide. and I will highlight in red the discussion that is forthcoming, that is coming up. Now, a version of this PowerPoint is available to you. Certainly, Vanessa can distribute it where you'll go ahead and see both topics handled. The topics we're going to be handling today, as well as next class, next session, will be handled in that PowerPoint. So let's start with, is there even a statement? So we start by looking at the definition of hearsay under Federal Rule of Evidence 801. Now, the rule requires, the 801 basically defines hearsay as a declarant's out-of-court statement offered for the truth of the matter asserted. Okay, that's the definition under Federal Rule 801. And what I'd like to go ahead and do is go over each one of these components here. Now, we're going to spend a lot of time on number 3, and we're going to spend a lot of time on number 4, but certainly we should also take a look at number 1 and then quickly take a look at number 2 as well. So let's get started with what is a declarant. Now, that's very straightforward. A declarant, has to be a human being. It cannot be a dog. It cannot be a machine. So if you have, for instance, your client is, charged with transporting narcotics in her car, and Fido alerted to the narcotics in the car. Now, you can challenge that on many different grounds. Perhaps Fido is not properly trained. Perhaps Fido was responding to an improper signal of Fido's handler. You name it, but it's not going to be hearsay. So that's not to say that you cannot challenge it, but it's not hearsay. What Fido does is not the subject of hearsay analysis simply because Fido's not a dog. Same thing with machines. Let's take a quick look here at an example. And again, I mentioned that I'm going to be talking about 14 cases. The cases are designed to be great cases for where you're in court litigating, and you can pull that case quickly and go to a defense favorable case that you can argue to the court. This one is just an example. This is not a defense favorable one, but it illustrates the point. And this is United States versus Hamilton. And let's talk about Hamilton real quick here. So basically what we got here is the takeaway from it. And what I'll do is that when I'm talking about the cases, same way that is, again, it's done in my book, A Defender's Guide to Federal Evidence, is that, we start with a case. The case has a quick, one-line blurb, and then we go into a summary. That's the way we're going to handle it here too. So basically, the one-line takeaway from this is that computer-generated headers on documents are not hearsay under 801, under Rule 801, because there is no declarant. The computer is not a human being. That is assuming, of course, that this is something that is automatically generated by the computer or whatever other machine, something where there is not human intervention, human analysis, and that sort of thing. Let's look at what happened in Hamilton. In Hamilton here, in this case, the defendant was convicted by jury of transporting child pornography in interstate commerce. The government introduced 44 images that contained a computer-generated header, and the computer-generated header had such information like screen name, date the image was posted, as well as IP address. Now, obviously, all those things could be very relevant in a case and certainly could be quite incriminatory. Now, the defendant objected on the basis of hearsay to all this header info. And again, the header info was screen name, date, IP address, etc. Now, the district court overruled the objection. Now, on appeal to the 10th Circuit, the circuit held that the district court correctly analyzed the matter and concluded that in this case, the header information was not hearsay. According to the 10th Circuit, the header was generated instantaneously by the computer without the assistance or input of a person. And because of that, because it was computer generated, then there is no declarant to speak of, and consequently, the definition of declarant is not met. And if it's not met, then we don't have statement, we don't have hearsay. Again, that is not to say that you cannot challenge that under other grounds. Absolutely, you can. It may be, for instance, that the computer is not properly synchronized, that the time that it's showing is incorrect. If you can challenge the IP address as having a number of different problems, but again, from a hearsay standpoint, that is not going to be hearsay, as it is not a human being that is mediating that. And again, here the critical part of this opinion is that according to what the circuit said, the header was generated instantaneously by the computer without assistance or input. If there was assistance or input, then certainly that would be a different story, and you can analyze it. We can analyze it under a hearsay, a standard hearsay analysis. All right, now another definition, as we saw, is that it's got to be an out-of-court statement. And of course, it can be out of court, even if the declarant is repeating what they said on the stand. So you got the declarant on the stand, the declarant is repeating what they may have said out of court, that could still be hearsay. This is a concept that oftentimes my law students have a hard time grasping, and I have to spend some time in every class dealing with this issue, that yes, you can have the declarant on the stand repeating something that they said, and that can certainly still be hearsay. We're not going to spend a lot of time on that, but it's important to remember that. Now, let's look into what is a statement. Now, first of all, the way that the rule defines a statement is by saying it's an assertion, but it doesn't define what an assertion is. So, in that sense, the rule is not necessarily very helpful. While not defining the federal rules, the case law has time and time again basically defined it as a declaration that something is the case. Now, one of the easiest ways of defining it is by comparing it with other things. Typically, for instance, an instruction, a question, a command, it's not going to be hearsay. It's not a declaration that something is the case. So for instance, if I say, it is raining, I am declaring something. It is raining outside. The car that just drove through Las Vegas Boulevard, you can see Las Vegas Boulevard right behind me, is green. That is an assertion. The green car was going fast. That is also an assertion. But if I put it in the way of questioning, is it raining? Then that is not. It is a question. I am not asserting anything. I'm asking a question. Same thing with typically a command would not be hearsay, but not always. And that's something that we need to go ahead and be on the lookout. So while questions are typically not a statement, they're not an assertion, sometimes they can be contextually. Let's take a look at an example. This is a great example. It's discussed in my book, and it's something that it may certainly come up. A prosecutor, very full of themselves, is arguing to the court that questions can never be assertion. Well, in the right case, you may be able to go ahead and say that yes, they can be. Let's take a look at this case. It's a great case here. This is the Summers case. Now, let's look at what happened here in the Summers case. This is a defense favorable case. Again, out of the 14 cases that we're going to talk about, the only one that was not a defense favorable is the prior one that I gave, and that's simply because it was an example. Now, what happened here in Summers, this is here the defendant was convicted of bank robbery and conspiracy to commit bank robbery. And what happened is that shortly after the robbery, the police stopped, a car. The defendant was an occupant in the car, and in the car, the police ended up finding evidence linked to the robbery. Now, the defendant was did an outstanding job in this case. The defendant didn't say anything. They didn't make any remarks to the police or anything like that. But the co-defendant, who was an occupant, makes the following statement: "How did you find us so fast?" He asked that of the police. Now, and the officer testified to that the co-defendant has said, "How did you find us so fast?" Now, the defendant objected. The defendant objected, based on hearsay grounds and confrontation grounds as well. But we're going to be looking at the hearsay piece of things. But the district court says that's a question. Of course, what happened here is the prosecutor got up, and the prosecutor pretending to be, McCormick on evidence, and the prosecutor says, no, questions can never be hearsay. And this is a classic example of that. The question was, how did you find us so fast? Now, on appeal, the 10th Circuit, however, had a very different take on things. And the 10th Circuit, held that the district court erred in admitting the question. The circuit noted that in some instances, a question can indeed be an assertion, consequently a statement that would be analyzed under Rule 801. Now, according to the circuit court, in this case, the co-defendant did intend to make an assertion. It is all about the individual's intent. Am I intending to declare something? Now, according to the circuit here, and I quote, "It begs credulity to assume that in positing the question, the co-defendant was exclusively interested in modern methods of law enforcement." Why does the court have to use credulity and positing? Nobody uses those words, but that's the way the circuit could put it, and then put it in a way that can be, again, quite helpful to us in the right case. Instead, the circuit said the statement intimated both a guilt, being a statement, and wonderment at the police ability to catch the suspect so quickly. According to the circuit, the co-defendant intended to make an assertion here that was apparent, and consequently there was a statement which needed to be analyzed under Rule 801. This was hearsay, and the district court erred in excluding it. Perhaps we may not find this particular problem too often, but occasionally you will. Certainly, I have been faced with this situation at trial. So just be on the lookout. Simply because something is phrased in the way of a question doesn't mean that it's not a statement. Okay, now let's go ahead then and continue with our discussion of what a statement is. Now, a statement can be oral or written, and it can also be nonverbal conduct intended as an assertion. So this, for me, goes back to my days many years ago taking evidence in law school, and this was over 30 years ago. And I had an incredibly nice professor for evidence. He was brilliant. I mean, extraordinarily accomplished. I've never tried a case in his life. I never set foot in a courtroom in his life. So we ended up basically spending most of our evidence course dealing with the nonverbal conduct intended as an assertion. He was obsessed with that. He loved that issue. And we talked and talked, and you may remember from your own classes about the example of the umbrella. All right, now if somebody is outside and they open up their umbrella because it's raining, is that a statement? Is that an assertion? Of course not. But if I am talking to you and we're talking, is it raining? We don't know. You can't tell. It's foggy outside. It's unclear whether it's raining. But I'm going outside, and you're looking at the window. I go outside, and then I look directly at you. I open the umbrella. Perhaps I point at the umbrella. I am clearly making an assertion to you. I am telling you it is raining. We were talking a minute ago about whether it was raining or not. Now I'm telling you it is raining. Anyhow, again, my professor ended up spending an inordinate amount of time devoted to that. Also one of the reasons I had to end up kind of like learning evidence on my own. But occasionally this issue will present itself in our cases. And we need to, again, know what the parameters of this are. And to really tackle that, instead of talking, for hours about theory and what have you, like we did in my law school class, let's go ahead and look at this example. This is a great example that illustrates this point, quite well. And again, this was another one of those cases where the government, thinks that it's doing something very cute, doing something whereby they can go ahead and get around the rules and that sort of thing, and bring in something as that perhaps may have been considered hearsay, bring it through that back door. The case is Martinez, and again, the quick takeaway is that under the Federal Rule of Evidence 801, a doctor's nonverbal conduct in a video made in response to an FBI request constitutes a statement. Let's talk about this a little bit more. So here, the defendant, who was an anesthesiologist, a doctor, was convicted of distribution of controlled substances and healthcare fraud resulting in death. Okay, we see this kind of cases, unfortunately, a lot. We've handled this kind of cases a lot in the past number of years. This is something that certainly is very much in the government's radar screen. So what happened here is that at trial, the government went ahead and relied on a video. This video was of a different doctor that was administering a nerve block injection procedure to demonstrate the proper way that procedure had to be administered, had to be done. That was part of the case. So again, the government presents at trial this video, and in this video, this other doctor, not the defendant was a doctor, but this other doctor is demonstrating how to go ahead and perform this procedure. Now, the defendant is getting convicted, and on appeal, the defendant argues that this was improper hearsay, that this video that the government introduced was hearsay. The government is saying, how can this be hearsay? Nobody's saying anything. Doctor, we're not even really focused on this part right here, on what the doctor said or didn't say. The doctor's just demonstrating things. Well, the Sixth Circuit in this case noted that first of all, that the doctor's conduct was a statement. The circuit reasoned that the doctor made the video in response to an FBI request, and the purpose was to demonstrate the proper performance of nerve block injection, the proper performance of a procedure, a medical procedure that was relevant in the case. In this case, according to the circuit, the Sixth Circuit, the doctor's conduct was an assertion of a proper medical procedure. Consequently, the doctor's conduct in this case was nonverbal conduct intended as an assertion that needed to be analyzed as hearsay. The district court failed to do that. The district court just gave it a green light once the government said this is not hearsay because The doctor didn't say anything. The district court, goes with it, and now the appellate court says that was error. Okay, so very nice case for that sort of scenario. Now, so we talked about what is the definition of hearsay, and for the definition of hearsay, of course, we went ahead and we covered the four elements under the rule. We talked about a declarant. We talked about what is a declarant. We talked about the statement being made at a court. We talked about what is a statement. And next, we're going to be talking about the all-important topic of a statement being offered for its truth under the rule. Again, something that prosecutors love. This is along with co-conspirator statements, which we'll be talking about later in this session. This is another darling of prosecutors. Prosecutors love this because they know that oftentimes judges just go with it. They hear the prosecutor saying, oh, this is not used for the truth of the matter asserted. It comes in, and that's the end of the analysis. So let's cover this here. Now, not for the truth of the matter asserted it's a broad area, and it covers such things as course of investigation. We're going to spend a little time talking about that simply because it's so heavily exploited. But it also covers such things that affect on the hearer, reader. It also covers knowledge, impeachment, etc. And we'll talk about a number of examples that will flesh this out. Now, let's first look at how the government typically would use this. Now, one of the main ways that prosecutors use this is under the course of investigation rubric. They love that, and it is abused constantly. Now, so the idea is that a statement is not hearsay, is offered to show why an investigation was undertaken, how an investigation proceeded, etc. That's in the theory. The problem, again, is that this is an area that is heavily exploited. And oftentimes, once the prosecutor invokes it, the district court will just simply go ahead and let everything in wholesale. So now, important things to remember here is that as far as in the course of investigation, this is subject to 4-3 analysis, like most everything else in evidence, and that typically, ordinarily, testimony that the offer acted on information should suffice. There's no need for the officer to go ahead and go into details that clearly inculpate our clients. Now, let's go ahead and then look at how this worked here. Allow me 1 second. So this here is the Becke case, and this is a great case that illustrates how this plays out here. And let's look at the Becke case. Now, and again, the one-line takeaway is that statements that go to the heart of what the government is required to prove are hearsay and cannot be disguised as background information. Again, that's kind of how in my book, The Defender's Guide, is basically laid out. And so we start with the case, then a one-line summary, and then the larger summary of the case. Here in Becke, what happened is that the defendant was convicted of drugs, firearm charges. This is a case that we all have seen at one time or another. I don't know how many times this has happened to me. Certainly has happened to me a ton of times in trial, when basically what you have is that the government puts on an officer and the officer testifies to something like what happened here. And let me quote what the officer here testified, that an unidentified, non-testifying confidential informant told him, the officer, that the defendant was selling meth and manufacturing hash. And also, they just because they can't help themselves and they can't stop right there, and they have to go ahead and have their cake and eat it too. The officer also has to say that the informant provided true and reliable information. All right, so let's look at that then. The defendant, of course, objects to his testimony. The district court says, I don't see a problem with this. This is not being offered for the truth of the matter asserted. This is simply being offered to show how the investigation, proceeded. And, and we all have heard this argument 1,000 times. What do you expect, counsel? If the prosecutor doesn't have the right to go ahead and talk about how the officer started investigating the case and why they zeroed in on the defendant's house and all that, then the jury is going to be blind, and that's not fair, and blah, blah, blah. That's exactly how it happened. That's exactly how it's happened to me countless times. Well, the 10th Circuit wasn't having it here, and it held that the district court erred in admitting the evidence. The 10th Circuit noted that the evidence that the government presented to explain the course of investigation, again, you hear this referred to as course of investigation, background for the investigation, etc. The bottom line is that what the government is trying to get at is that this is not hearsay because it's not being used for the truth of the matter asserted. Now, so the 10th Circuit noted that the evidence the government presented to explain this course of investigation went to the very issue that the government was required to prove. The 10th Circuit put a lot of emphasis on this, on what I'm going to say next also, and always keep an eye on this. The government will say, Your Honor, we're just using this not for the truth of the matter asserted. We're just using it to show background investigation, whatever it may be. But then in closing argument, they'll go ahead and argue it as if that was the truth. They argue for the truth of the matter asserted, and that's exactly what happened here. In this case, the prosecutor referenced the out-of-court statement and argued that we know that at least 48 hours prior to the search warrant, there was meth in the defendant's residence. This is a quote from the prosecutor's closing argument. We know that at least 48 hours, blah, blah, blah. And why did they know that? According to the prosecutor, they knew that because the officer had been told that by this unidentified, non-testifying, confidential informant. So, it's all baloney. I mean, the prosecutor argues that it's coming in for the truth of the matter asserted, but then they end up arguing it as if it was the truth in closing argument. The 10th Circuit said here that the evidence directly implicated what the issue of guilt, and the government clearly relied on the informant statements as being truthful. Great case, again, when the government is talking about background of the investigation. Again, one of the most common abuses when it comes to statements that come in under not for the truth of the matter asserted. Let's look at another example. This one is also a really nice one too. This is the Cass example, and this is another 10th Circuit. Don't worry, I mean, you've seen several 10th Circuits, but later on we'll get into a bunch of other circuits. Certainly, this is not a 10th Circuit happy presentation. I'm actually from the 9th Circuit. It just happened to be that there's some good cases in this area from the 10th Circuit. But let's look at this one here. This is the Cass case. This is a great case, also one of those cases that you want to have in your pocket, ready to go if you're in trial and you fear that this issue about background investigations may be coming in. So again, the takeaway here, the one-line takeaway, background information directly inculpates the defendant is hearsay, regardless of the prosecutor's argument that this is not for the truth of the matter asserted and all this other stuff. Now, so let's look at what happened here. The defendant here was convicted of making a false statement to an FBI agent. Now, what had happened is that the defendant reported that she had been kidnapped and sexually assaulted. The FBI, however, had information that she had been with her boyfriend at the time that she claimed to be kidnapped. She was married, and the FBI believed that all this had to do with a love triangle type situation, and that she was with her boyfriend at the time. Now, at trial, what happened is that the FBI agent repeated a number of statements made by people that they interviewed in the course of the investigation, including the defendant's husband, the defendant's employer, and other individuals, even including a taxi driver and that sort of thing. The sort of series of statements that had to do with such things as location of the defendant and a number of other things. But the prosecutor, of course, tried to go ahead and admit all this, successfully admitted it actually at trial by arguing that this was not coming in for the truth of the matter asserted, but rather that it was coming in to show background as to how the investigation progressed. Okay. Now, the 10th Circuit again is not having it. The 10th Circuit is saying this is just rank hearsay, and not only is it rank hearsay, it's rank hearsay that goes to the very heart of what the government is supposed to be proving, that the defendant lied about being kidnapped. All the statements that the prosecution presented in the guise of background information had to do precisely with the issue of the defendant being kidnapped. So according to a circuit, and it's a nice quote, it's from the circuit here, police witnesses may not simply repeat on the stand what other witnesses have told them and justify their practice by arguing that the statements are introduced to explain how they went about the investigation. Nice case if you have this. Again, this is another area that is quite commonly exploited by the prosecution. Now, I gave you two cases here that are defense favorable cases, but they're from the prosecution trying to use this evidence here, trying to use it to justify background. Let's go ahead and talk about cases where it's the defense that is trying to present the information. And of course, in those cases, as we commonly experience, courts are much more inclined to exclude what we are trying to go ahead and present. Very ready to include what the prosecution is trying to present, but much more willing to exclude what we are trying to present. So here we're going to be talking about examples such as effect on the reader, listener, entrapment, and that sort of thing. This is defense-sponsored evidence. Now, this is another great case here, the Feliz case, a really good case. This is a case from the First Circuit. And what happened here is that the defendant was convicted of possession of a firearm in furtherance of drug trafficking crime. Now, and also drug trafficking related counts. Now, what happened here is that the police had searched the defendant's stepfather's home, where they suspected that the defendant had his stash and had weapons and that sort of thing. So they searched the stepfather's home. The defendant in this case was a kid, 18 years old. Now, when the defendant was not home at the time of the search, but what happened during the search is that at one point the defendant shows up, he's transported to the station, and according to the officers, the defendant gives 2 full confessions, written confessions, one to the local police and another confession to the FBI. And according to the police, basically what the defendant confesses to owning the drugs, money that was found, weapons, etc., and also saying that his family had nothing to do with it. Now, this account, unsurprisingly, was very different from the account that the defendant was going to give a trial, and more importantly, and for our purposes, that his mother was going to go ahead and give. And again, I hope that you can see me clearly. I can see myself in the screen that has me. It's a little bit dark, but I do hope that you can see me. I've been trying to manipulate the camera so you can see me better. So let's talk about what happened, here. So according to the defendant and his mother, what had happened is that after the police searched the house, the police told the mom to call her son. And what both the defendant and the mother maintained was that an officer took the phone from her, and that the officer told her son to turn himself in because the drugs, money, and weapons were his. That the officer also told the defendant that if he refused to turn himself in, his siblings, he had a number of young siblings at the house, would be sent to the custody of the Department of Public Affairs. And in addition to that, that if he failed to turn himself in, that his mother would be deported. His mother was Dominican. So you got 2 completely different versions of what happened here. Allow me 1 second. I want to try one more time to see if I can make the screen here a little bit better here. It just hopefully that helped a little bit. Now, so again, this is disputed. The statement as told by the police is disputed by the defendant and his mother.
What was the name of that client that I did a motion to quash the search warrant, and I almost won, but he ended up having to do 2 years?
Was that?
County?
Yeah, he lived in LA. He would come here to do it.
David Torres, you're not on mute. David?
Thanks, Nina. I think we got it. And sorry about that, Rene.
Oh, no problem at all. No problem at all. All right, then. So, so again, the defendant here, the defendant wanted to put his mom on the stand to testify as to what had happened, that the police came in, that the police ordered her to go ahead and call her son, that the police made a series of threats to the son when they had him on the phone, that the mother called, then they took the phone away, and then they made a series of threats to the defendant that if he did not admit that his siblings would be sent to the Department of Family Affairs, that his mother would be deported, etc. Now, the district court, however, precluded his mother from testifying, and the court did that on hearsay grounds. According to the court, what the mother had said was hearsay. So now on appeal, the First Circuit held that the district court erred and in excluding the testimony of the mother. According to the court, the testimony was not being presented by the defendant. The testimony of the mother, it was not being presented for the truth of what had happened, rather for the effect on the defendant, for the effect on the listener, that is the reason why the defendant went ahead and confessed, and that he felt coerced to confess because of what he had been told by the officer. That was the purpose of the defense wanted to go ahead and bring in the testimony. The district court excluded it, the First Circuit says that's error, and that the evidence should have come in, that the evidence presented by the mother should have come in, and the First Circuit here vacates the judgment and conviction, remands the case. Excellent case if you have the situation. This is, again, different from the ones where we're talking about background information as presented by the prosecution. Here, it's the defense that's trying to go ahead and present the evidence, and the district court excludes it. Another situation where we have the defense sponsored evidence that we're trying to bring in, and that oftentimes is excluded by district courts, is in the context of entrapment, when we're trying to go ahead and run an entrapment defense. And this is a great case on this, is the Cantu case. This is a Fifth Circuit case, and the takeaway here, the quick takeaway, is that the defendant's statement that support his entrapment defense are not hearsay. They're not being introduced for the truth of the matter asserted. Instead, they're being introduced for the purpose of showing that the defendant was responding to coercion or threats or whatever it may be in the part of say, an informant, which is what happened in this case. So here in Cantu, the defendant was convicted of conspiracy to import in excess of 100 grams of heroin. And there were two informants involved in the case. One testified and another one did not. Another one was in Mexico. And the defendant testified as to what that particular informant wanted to testify as to what that particular informant had to say, the informant in Mexico. This informant, according to the defendant, had tried to induce the defendant by repeatedly calling him and enticing him, etc., to go ahead and sell the narcotics. Now, the district court excluded the evidence based upon the government's motion in limine to prohibit the defendant from testifying about anything connected to the informant that was in Mexico. Informant actually was incarcerated in Mexico. Of course, the prosecutor had no problem, using using the fruits of what this informant incarcerated in Mexico had done. Now, so the trial court, excludes this information regarding this second informant. And at trial, the defendant is prevented from testifying about this confidential informant's persistent trying to secure customers from the defendant. Now, the Fifth Circuit here noted that the defendant sought to testify about the confidential informant's persistence, and that the statements were not offered an assertion of fact, but rather simply to show that the assertion took place. That, in fact, this informant had tried to entice, to coerce, to convince the defendant from to sell drugs. So the statements were not offered to prove that the confidential informant really wanted the defendant to sell drugs, but rather to show the impact that they had on the defendant. Because of that, the Fifth Circuit went ahead and reversed and remanded the case. Okay, now let's talk about a third case that this is also a defense favorable case. This is one where the defendant is alleging at trial, as we'll see in a second, that he was basically an undercover agent. The agents did not see it that way. And allow me 1 second. I want to try to do something else to see if that helps. with the image here. At any rate, this is a Parry case, is a great case. And here the bottom line is that statements that the defendant was aware of the existence of some fact are not hearsay. Let me hash that out so you can see what I'm talking about. Here, the defendant was convicted of distributing PCP and possessing with intent to distribute PCP. Here, two undercover agents testified that the defendant acted as a middleman, as an intermediary in arranging several drug transactions, three different drug transactions between the agents and between the agents and other individuals. That's basically what the undercover agents were testifying to. Now, the defendant argued that while he did participate in the transactions, that he believed that basically he was working for the agents, that he was an undercover agent. That was a theory of defense. And to show that, the defendant wanted to have, once again, his mom testify. This is a different case, but wanted also his mom to testify. And the subject of the testimony was going to be that that his mother had asked him what he was doing because he had been called a number of times by this individual. So his mother was curious about what was going on. Why was he speaking to this individual and this and that? And the defendant had told his mom in response to her questions that the person he had been talking to frequently recently over the phone was an individual that was a narcotics agent, and that the defendant, was helping that agent. Now, so again, the defendant wanted his mom to corroborate that story. His story was that he was an undercover agent in his mind for this agent, that he was helping the agents, and that's why he was engaging in this drug dealing. So he wanted the mom to testify. The district court said, no, this is hearsay, and it's not coming in, and the defendant was prevented from presenting the testimony of his mom. Now, on appeal, the Fifth Circuit held that the trial court erred in excluding the defendant's mom's proffered testimony. Unfortunately, the defense had done in this case a very nice job at presenting an excellent proffer by the mother in this case. So they had that preserved for appeal. Now, the Fifth Circuit said that in this case, the testimony was not being offered for its truth. Instead, it was being offered to show, it was being offered as circumstantial evidence that the defendant had knowledge that this individual was an agent, and that in his mind, he was acting as an undercover agent, helping out the agents in this drug transaction. So the Fifth Circuit noted that using is out-of-court utterance as circumstantial evidence of the declarant's knowledge was not in violation of the hearsay rule, and the court reversed and remanded the case. An excellent case if you are in a situation where you're intending to present a similar defense. This again is us, the defense, trying to go ahead and bring in evidence and making the argument that that evidence is not hearsay because it's not being used for the truth of the matter asserted. Okay, so then let's go ahead and go to our third component of today's lecture, today's presentation. And again, it's always good to be here with you. I'm very thankful that you're taking the time, and thanks Vanessa and Nagdal for having me today. next week, as we talked about, we were going to be discussing exceptions. And next week, I'll make sure that that if indeed I'm having an issue here with my camera being too dark, that is addressed. Now, let's look at statements that are categorically not hearsay under Federal Rule of Evidence 801. We already did the analysis of, is there a statement? Is there hearsay? Is the statement being used for the truth of the matter asserted? So now we have a statement. The statement is being used for the truth of the matter asserted, but it's going to go ahead and fall, not under an exception, under an exclusion under Rule 801. So what do we have here? We have basically two big groups of exclusions. And one is declarant witnesses' prior statements, and another one is the opposing party statements. We'll talk about both in turn, and both obviously come up very frequently in a trial. Now, as far as the first group, we're going to have declarant witnesses' prior statement as our first group. Our second group is going to be opposing party statement. We're going to talk first about declarant witnesses' prior statements, and those we can go ahead and basically put into three subcategories. And that is, the first one is going to be prior inconsistent statements given under oath and subject to cross-examination. The second one is going to be prior consistent statements offered to rebut a claim of recent fabrication. And then lastly, statements of identification. Again, all of these are things that we very frequently come into contact with. So let's take a look here at prior inconsistent statements. Prosecutors often rely on this, and judges often let them in, and oftentimes because judges, certainly prosecutors, misunderstand this rule and its application. So let's look at the elements for this to actually be able to come in. First of all, you have to have a declarant testifying at the current proceeding. So if you're at trial, you have to have that declarant, the declarant that made the out-of-court statement, it's got to be testifying in court and subject to cross-examination about the prior statement. And we'll talk about instances where the declarant may be there, but courts have found that that actually they may not be subject to cross-examination because the individual refused to go ahead and answer questions. So you have to have the declarant testifying, subject to cross-examination. Second thing that's got to be met in this case for this rule to apply is that the declarant has to have given a prior statement, and that prior statement is inconsistent with a statement currently being made in this proceeding. But that prior inconsistent statement was made under oath at a prior proceeding. This is another area that often is misunderstood by courts and abused by prosecutors. And one of the ways that it is misunderstood and abused by prosecutors is that the statement has to be made under oath at a prior proceeding. Prior proceeding could be at a prior trial, at a prior sentencing, at a prior grand jury proceeding. All that qualifies. But a police interrogation, even if it's under oath, even if it's being recorded and all that, is not at a prior proceeding. Does not qualify as a prior proceeding. So it has to be something that has, again, the flavor of a trial, of a sentencing, of an evidentiary hearing, that sort of thing. Now, let's look at an example of a defense favorable example of the prosecution invoking this rule when the elements of the rule have not been, in fact, met. And This is the Torres Ortega case. This is a very nice case for us. Because again, one of these cases that if you think the prosecution is going to be invoking this rule, you want to go ahead and have this case. Now, basically what this rule or what this case teaches us is that for a prior inconsistent statement to be used under Rule 801, a witness must be subject to cross-examination. So a witness has to be subject to cross-examination for the prior inconsistent statement to be used. Let's look at that. So here what happened is that the defendants were convicted of conspiracy to possess with intent to distribute both cocaine and marijuana. Now, a witness testified before the grand jury. Now, we're at trial now, but this is before. At a grand jury, a witness has testified about the drug distribution scheme and had implicated the defendants. Okay. At trial, so now that was before, that was at the grand jury proceeding. At trial, despite a grant of immunity, this individual, this witness, asserted the privilege, the Fifth Amendment privilege. Now, the court found that the privilege was improperly invoked by the witness, but the witness nonetheless refused essentially to testify, answer some questions, didn't answer some other questions, and in cross-examination, the witness didn't answer most of the questions. So what happened here is that and at the last presentation, we talked about the fact that any party can ask for a witness to be declared hostile under Rule 607. That's what happened here. The prosecution asked that this witness be declared hostile, and what they did is that they went ahead and once the court declared the witness hostile, they introduced the prior grand jury proceeding, which was highly inculpatory of the defendants. Now, of course, the defendants, once that happened, ended up getting convicted. And on appeal, the defendant argued that the admission of the witness's grand jury testimony was improper. So let me go ahead and again kind of review where we're at so we're all clear on things. Now, this witness had testified at a grand jury proceeding. The witness implicates the defendants. Now we're at trial. The witness is a recalcitrant witness. The witness doesn't, want to actually testify. The government says he is an adverse witness and a hostile witness. And under 607, the government asked the court to introduce his grand jury testimony. And the district court is more than happy to oblige and allows the testimony into evidence. Now, on appeal, the defendant argues that this is a violation. The defendants argued, those two defendants, that this is a violation of Rule 801, and the 10th Circuit agrees. The 10th Circuit held that the trial court erred in admitting the grand jury testimony because the witness was not subject to cross-examination as the rule demands. Again, as you can see here, the declarant must be testifying and subject to cross-examination for this rule to apply. That didn't happen here because it was a recalcitrant witness, and the witness barely answered any questions in cross-examination. So according to the 10th Circuit, this witness here was not really truly under cross-examination as required by the rule. According to the 10th Circuit, the district court erred, and in this case, the 10th Circuit reversed the conviction and remanded. Very nice case for us. I'm going to go ahead and ask for your patience for a second. I'm going to try to change positions of my screen to see if that may help in giving you a clear image. So my apologies for that, but I'll try to do that to see if that in any way helps. I hope that that gives you a clear image of me at least. So hopefully that helped. And again, my apologies for doing that mid presentation, but certainly blame that on the Las Vegas sun that is hitting here in Las Vegas Boulevard right behind me. So I hope that that did help and that you can see me a little bit better there. Okay, so let's continue on then. And this is again prior inconsistent statement that we just finished discussing. Gave you a nice example, Torres Ortega, of a situation where you have a court saying, no, there was not proper cross-examination as demanded by Federal Rule of Evidence 801. Now, let's move on to prior consistent statement. Okay, prior consistent statement. Now, here basically what the rule requires is that you have the declarant, the person that made the out-of-court statement has to be on the stand and also has to be subject to cross-examination. So far, this is very similar to the requirements of prior inconsistent statement. A difference here, however, is that the prior statement, in this case, of course, we're now talking about prior consistent statement. The prior statement does not need to be made under oath, nor does it have to be made at a prior proceeding. So in that sense, prior inconsistent statement and prior consistent statement are different, but the first part is the same. The first requirements are the same. The declarant has to be testifying at a current proceeding, a trial, say, and subject to cross-examination about a prior statement. Now, the additional requirements is that our prior statement has to be consistent with the testimony, and it's being offered to rebut expressed or implied charges of recent fabrication. This is going to be critical, as we will see in an example that I will go ahead and talk about in just a moment here. But the rule requires that the prior statement be consistent and offered to rebut expressed or implied charge of recent fabrication or improper influence. Now, the rule also talks about the rule was amended in 2014 to also add or to rehabilitate the declarant when attacked on other grounds such as, say, bias. But that is significantly rarer, and usually what you will see is that the prosecution, say, is trying to bring in this prior statement to rebut an expressed or implied charge of recent fabrication after we, say, impeached their witness. Now, let's talk about a nice example, and this is the Tomei case. This is a U.S. Supreme Court case that hashes out the requirements in this rule. Now, here, the quick takeaway under, for this rule, under this case, is that a prior consistent statement is admissible if it was made before the alleged fabrication, influence, or motive came into being. Let me go ahead and flesh that out. But again, this is very important because oftentimes you see prosecutors trying to bring in what they consider to be prior consistent statements, but the prior consistent statements were made at a time when already that improper influence or motive already existed. So here what happened is that the jury convicted, this case is on habeas, so we want to be talking instead of the defendant, the petitioner. But here a jury had convicted the petitioner of sexual abuse of a child, his daughter. Now, prior to this conviction, the petitioner and his wife had divorced, and a tribal court had awarded joint custody of the child between the ex-wife and the petitioner. The petitioner, however, had primary physical custody. Now, at trial, the theory of defense was that the allegations were concocted so the child would not be returned to the father. So, in this case, the defense was arguing that the mother had concocted these allegations so that the child would not be returned to the father, to the defendant. Now, here, what happened is that the prosecutor presented 6 witnesses that made statements concerning to what the daughter, the petitioner's daughter, the victim, the child victim, had told them. And basically the government presented them to show that what the child was saying on the stand, what the mother had said on the stand, was not a fabrication, that it was not there was not a story concocted so the child would not be returned to the petitioner, but rather it was consistent with what the child had told other individuals like the mother, doctors, counselors, etc. Now, in this case, the statements have been made after the divorce, after they issued the custody and all that, after all that had been, come and gone. And in this case, the district court allowed the statements into evidence. The 10th Circuit affirmed. The Supreme Court, however, said that the Federal Rule of Evidence 801D1B has a temporal component to it, a temporal requirement, and that a prior consistent statement is only admissible under the rule if the statement is made before the alleged fabrication, influence, or motive came into being. If the statement was made after, it is inadmissible. And in this case, the Supreme Court concluded that the alleged prior consistent statement of the prosecution brought into evidence should not have been admitted because they came into being or they were made after the reason for the alleged fabrication came into existence. So the temporal requirement of the rule was not met, and the Supreme Court, concluded that the 10th Circuit erred. The Supreme Court reversed judgment and remanded the case. Now, there's an important issue to keep in mind, and this is a great case, but let's look at another case. This is a 5th Circuit case. This is the Portillo case, and this is the way that this.
I apologize, but could I interrupt for a moment for some audience questions?
Absolutely.
So if this wasn't addressed in enough detail, one of our audience members says the requirement that the witness be subject to cross-examination refers to the instant hearing, not the previous hearing?
That is correct. That is correct. The requirement as to both. And again, that's an excellent question. And frankly, for a long time, I was confused on that. And finally, I got it straight in my own head. But let's go back to the requirements as to both. For 801D, that is prior inconsistent statement, the individual, the declarant, the witness who made the statement at a court has to be subject to cross-examination now at the current trial, and that's why I presented the Torres case. The Torres-Ortega case is an example of that. The witness is on the stand and in theory subject to cross-examination, but the witness is not answering questions. The witness is a recalcitrant witness actually for both sides. The witness is not wanting to answer the prosecution or the defense's questions. In that case, the 10th Circuit said there really wasn't any effective cross-examination to be had because the witness didn't want to go ahead and answer. So there was no cross-examination. The elements of the rule are not met, and consequently, the statement should not have come in. But it's the same thing for prior consistent statement. It is cross-examination in the current proceeding. Now, to make the point very clear, for prior inconsistent statement, the prior inconsistent statement had to have been made under oath at a prior proceeding. Okay, that is not the case. Just again, to be clear, with prior consistent statement. Prior consistent statements can be made to, not in a prior proceeding, can be made to, to a civilian, and they don't have to be under oath or anything like that. All right, so we talked about Tom. Oh, I'm sorry, and you had another question.
Yes, we have one more. So
okay.
So for this one, this question is about an interpretation. How broadly are courts interpreting the new language about rehabilitating the defendant? Are courts extending this exception much beyond the pre-existing permission to respond to allegations of fabrication? And if I didn't get the question right, Nina, please jump in.
So I love that question because it is really an excellent question. And the answer to that is that, they, relatively speaking, as far as, evidence type related issues, the amendment's still fairly new. There's not a ton of, case law out there regarding this issue. I think that courts are gonna be, my take on things is that courts are still gonna be hesitant to apply that, and that courts are going to be looking really more at the more traditional, the more traditional ground of prior statement consistent and offered to rebut express or implied charge of recent fabrication. That the second one, or to rehabilitate declarant, I think it's going to be interesting to see how things play out in the next years, and I think it's going to really behoove us to not allow prosecutors to use that as a backdoor to the more traditional requirement. Because, then all of a sudden, prosecutors are going to say, oh, no, we're trying to bring it in because of bias or whatever. This has nothing to do with recent fabrication and all that. But again, there has not been a lot of cases on it. I am very much hopeful that that we can continue pressing on and making the case that should be narrowly construed, because or otherwise that last exception, that's not the way that the advisory committee intended it to be, that that it can be cabined and read very narrowly. But very good question. I think that again, the key thing we need to do when prosecutors are trying to go ahead and argue that the statement should come in under the second one, that is the bullet point at the very bottom, or to rehabilitate the declarant when attacked on other grounds, that should be read very narrowly. Typically, it should fall under the traditional one, and that is that say we're attacking an informant, and we're attacking the informant because the informant obviously has reason to lie, they have reason to fabricate, etc. That should all be coming in under the traditional exception, not under the most recent one. I hope that I answered the question, but that is really an excellent question. It's actually something that I am keeping a very close eye on, and it's something that as I'm working on the second edition of the book, I'm really looking to see how this issue progresses. So congratulations, whoever asked that question, as that is a very good one. Now, so let's go to Portillo. this is a really good example too of this issue playing out. And here what we got is that under the rule, under 801 D1B, prior consistent testimony is not admissible when the motive to fabricate existed at the time the prior consistent statement was made. This is going to be the traditional informant example that we all see and that we see day in and day out in courtrooms throughout the country. So here, a jury convicts the defendants on multiple RICO-related counts and conspiracy-related counts. At trial, the government presents a testimony from two brothers who both implicated the defendants in a murder, a RICO murder. Now, on cross-examination, the defendants cast doubt on these two brothers. The two brothers were the ones that have made the statements concerning implicating the defendants in the murders. The defendants were not the brothers. The brothers were the declarants. On cross-examination, the defendants cast doubt on both brothers' testimony, suggesting that they were fabricating their stories in order to receive a benefit from the government. Now, after the brothers testify, the district court grants the government's request to introduce the statement under Rule 801 D1B in order to rebut the implication that the brothers have fabricated their testimony in hopes of receiving a lower sentence. So what happened is that here you got these two brothers. They testified. They were vigorously challenged by the defense. The government, then wants to go ahead and bring into evidence what they consider consistent statements that these brothers had made to the police regarding the involvement of the defendants in the case. Statements that were made when these brothers were arrested and questioned by the police. Now, so the district court lets all this stuff in, lets all this garbage in, and as according to the court, prior consistent statements under the rule, under 801 D1B. Now, the Fifth Circuit, however, concludes that the defendants, that in this case, the brothers' statements to law enforcement, even at the very beginning, even from the time they were arrested, even at the very beginning, were motivated by a desire to shift blame to the defendants in order to obtain the benefits of cooperation. According to the circuit, that was the same motive for them testifying on the stand. According to the Fifth Circuit, the statements that were made to the police at the time of the arrest of the witnesses, the brother witnesses, were made, based on the desire to go ahead and curry favor with the police. So, according to the Fifth Circuit, the statements that were made to the police by the brothers, when questioned, that those statements were already were tainted by the desire to benefit from those statements, and consequently, they could not fit under the protection of Federal Rule of Evidence 801 D1B. And according to the circuit, the district court erred because of that. So this is a nice example where, oftentimes you have the prosecutor making this argument. And so again, they have, you go ahead and, you batter up the government's witness, the informant, and the prosecutor here is rushing to get this prior statement. They say it's a prior consistent statement under 801. And you say, how's this prior consistent statement? At that point, they already had a motive to lie and all that, but the standard line of the prosecutor, but they were just arrested. This is not, we had not engaged in any negotiations yet, et cetera, et cetera. the Fifth Circuit, there says that doesn't make any sense. By now, the brothers already had an interest in making their case, incurring in favor and all that. So this is outside of the rule. So now we're going to go ahead and remember we talked about prior inconsistent statements, prior consistent statements, and now the third piece is going to be statements of identification. Now, this play out a little bit differently than our prior two consistent statements and inconsistent statements. So let's review here the elements of statements of identification. So first of all, again, you have a declarant testifying at the current proceeding, let's say trial. So we're trial. So you have the declarant has to be testifying at trial, subject to cross-examination about the prior statement. And the prior statement is one where the witness identifies a person as someone the declarant perceived earlier, a statement of identification. Now, this is different from, in a number of respects, from the other two rules that we discussed. And allow me to quickly go over how they are. Again, for prior inconsistent statements, we talked about how they had to be made under oath at a prior proceeding. This is the out-of-court statement has to be under oath at a prior proceeding, not the case with statements of identification. We also, discussed here with prior consistent statements that first the witness has to be challenged, and then for it to qualify, it's going to be a prior consistent statement offered to rebut, etc. Those requirements do not apply here. The only requirement that's applied is that it's got to be a witness on the stand, subject to cross-examination about the prior statement. That prior statement needs to be a statement of identification, of perceiving somebody and identifying them. That prior identification could have been of a photograph, a sketch, lineup, you name it. And it applies even if the witness is able to make an in-court identification. It still applies. Now, very importantly, however, it could be that the statement comes in under the rule, but still you have issues of suggestiveness, constitutional issues of suggestiveness of the identification. That's separate and apart from the from this rule. Okay, and again, all this that we have been discussing so far, prior consistent statement, inconsistent statement, statements of identification, those are hearsay exclusions. They are not exceptions. These are categorically not hearsay under the rules. Now, let's go ahead and now shift gears. And remember, we initially thought that we had two big baskets under the rule of statements that are categorically not hearsay. One was the statements of a witness, and those were prior consistent statements, inconsistent statements, statements of identification, the one that we just reviewed. But then we have another big basket, and that is opposing party statements. Now, this could occupy us for, frankly, an easy 2 additional sessions. And obviously, we're not going to do that because there's a number of categories. But what I'd like to go ahead and do is highlight 2. We're going to go ahead and, first of all, there's 5 categories. You got personal statements, adopted statements, statements by an authorized spokesperson, by agent employee, and most importantly for us, co-conspirator statements. Now, what I want to focus on are 2 things: adopted statements, co-conspirator statements. Adopted statements, I want to talk about them, and in passing, I want to talk, because it's important to talk about Doyle in this context. But again, we want to focus primarily here on co-conspirator statements. Now, so before we talk about co-conspirator statements, let's talk about adoptions by silence. There is such a thing as adoptions by silence, but for an adoption to qualify, I'm sorry, for a statement to qualify under this category as adoption by silence, a number of pretty rigorous requirements have to be met. The prosecution has to establish the following. If we're talking about our client, okay, and that is that the defendant heard the statement, that the defendant had the opportunity to respond to the statement, that a reasonable person in the shoes of the defendant would have normally denied the statement upon hearing it, and that the defendant failed to do so. It should be rare, but it can happen. And in that context, do recall, of course, always, Doyle, and that is that a prosecutor cannot, call attention to the defendant's silence after he or she was given Miranda. I want to talk about Doyle for a minute. I also have a case that is based on Doyle. I'm not going to really cover it, but it's an excellent case. It's a recent case. It's Ramirez Estrada. It's a recent interpretation of Doyle. But I find that it's always good to talk about Doyle, especially in the context of silence being used against our clients. Now, just everybody, of course, knows about Doyle. Most of us, studied it in criminal procedure and in law school. And what you got there is that the petitioners were convicted of selling marijuana, and in this case, both petitioners took the stand, and they claimed that an informant had framed them. Now, what happened is that again, here the defendants had taken the stand to testify. This matter was also on hearsay, so properly there were the petitioners as opposed to the defendants. But what happened here is that during cross-examination, the prosecutors asked each of the petitioners why they didn't tell that to the agents when they were arrested. So the prosecutors to this day, years, decades after Doyle, they still do that. And sadly, oftentimes, stuff like that comes in and nobody objects. And then at the end of the day, we end up, with a train wreck that has to be cleaned up in habeas. But here, what the prosecutor basically asked in cross-examination of the petitioners is that, so, now you're claiming that you were framed by the informant. Why didn't you tell that to the police when you were arrested? We would not be here, perhaps. It would have saved everybody the time and hassle and all that. So why didn't you do it? And of course, the argument then to the jury is that they didn't tell that to the agents, and they didn't tell that to the police. They didn't tell that to the police or the agents. And they didn't say that because it's a lie. They didn't, they were not framed. If they would have been framed, they would have told that to the police. That's essentially the argument. Now, of course, on appeal, both petitioners argued that the trial court erred in allowing the prosecutor to go ahead and allow that in. The circuit court did not see it, did not see the way of the defendant, did not agree with the defendant, but the Supreme Court did. The Supreme Court, held that the use for impeachment purposes of petitioner's silence at the time of arrest and after receiving Miranda violates the due process clause of the 14th Amendment. And of course, the Supreme Court reversed the conviction and remanded the case. So while not directly on point regarding our discussion on 801, it's nonetheless something that is very important to go ahead and keep in mind, especially when the prosecution starts going into the territory of our client having been silent for one reason or another during, say, arrest. Okay, Now, I said I was going to go ahead and skip the discussion on Ramirez-Estrada. Ramirez-Estrada is an elaboration on Doyle. It's an excellent case. If you have a Doyle, issue, to take a look at it as a defense win, and do take a look at it, but we're not going to cover it here, as I want to be sure to cover co-conspirator statements. So co-conspirator statements, and I mentioned, how co-conspirator statements are one of the components of opposing party statements. The logic being that if the opposing party made the statement, it's coming in. We have personal statements, unfortunately, we have to deal with all the time as far as our clients making statements. But where you see a lot of the litigation, where you see a lot of abuses from the government, and where frankly, I think that the rules are just totally favor the prosecution, and when it comes to opposing party statements, is in the area of co-conspirator statements, because the stuff that comes in under co-conspirator statements it's just outright junk. What you have, for instance, is the government has to show a series of things, but courts barely enforce them, and what courts allow the government to introduce in the way of co-conspirator statements is pretty astonishing. Now, the government, in theory, has to show that a conspiracy existed, that the statement was made during the course of a conspiracy, and in furtherance of a conspiracy. Those three are, in theory, pressure points that we can apply, but it's tough to go ahead and get traction on this one. But we'll see, that there's some good case law when it comes to the in furtherance of the conspiracy part. Now, here, prosecutors enjoy broad latitude in what they categorize and what they can get to introduce at co-conspirator statements. For instance, the government doesn't have to charge the conspiracy, for crying out loud, in order to go ahead and introduce a co-conspirator statement. And of course, we can use them to show that, say, the co-conspirator says something that is beneficial to our side. Only a prosecution can use them. So it's really, in a sense, a travesty, and something that has bothered me for years and years. In addition to that, statements from an indicted co-conspirator can be also used, as long as the government can establish that the declarant is part of the conspiracy, and the state of the law is bad. It's not very good for us when it comes to this. Nonetheless, we need to continue to obviously push. And as I said, there are areas where we can go ahead and get some traction. For instance, when it comes to the issue of in furtherance of a conspiracy. And the key thing there is that idle conversation is not enough. Casual conversation about past events is not in furtherance. It's not going to go ahead and be enough. Now, let's talk about the Darwish case. I put this illustration here because this is it's an old British illustration. The witness who introduces foreign matter into her evidence. How many times have I had witnesses government witnesses who introduce foreign matters into their evidence? Uncountable. I'm sure you have the same experience, but I thought it was a good illustration for this. At any rate, this is a really good case. The Darwish case is a good case that illustrates the point of in furtherance of a conspiracy. Let's talk about Darwish for a moment here. Basically, what Darwish instructs is that casual conversation about past events is not in furtherance of a conspiracy. So here what we have is that the defendant was convicted of conspiracy to distribute marijuana for selling customers marijuana in a store that he owned, a little convenience store that he owned. Now, a government witness testified that the defendant was selling about a pound of marijuana a day, more or less. When questioned about how that witness arrived at this figure, the witness noted that his nephews, the witness's nephews, worked as marijuana baggers for Darwish, for the defendant, and that they would tell him that oftentimes they would go ahead and bag 1 to 2 bags of marijuana for Darwish a night. That is 1 or 2 pounds of marijuana a night, that they would bag that quantity for the defendant Darwish, and they would break it down into smaller baggies and that kind of thing. Now, the defendant argued, this is not in furtherance of anything. This is just idle chatter. This is just talk. The district court, of course, didn't agree, let the statements come in. Unsurprisingly, Darwish, gets sentenced to having to dealing in excess of 2 pounds of marijuana a night. The Sixth Circuit on appeal holds that the witnesses' statements were not made in furtherance of the conspiracy. The circuit, first of all, says that it is clear that mere idle chatter or casual conversation about passive events is not in furtherance of anything. The nephew's statements, and this is the witness's nephews, their comments about how much marijuana they bagged or didn't bag for Darwish were not an attempt to keep the co-conspirators appraised of anything. They didn't serve to identify participants and their roles. They didn't serve to plan logistics for the conspiracy. In short, they didn't further anything dealing with the conspiracy. Instead, they were just pure casual conversation, idle chatter, and in a sense, they were absolutely no different from a farmer that basically was talking about how many acres of wheat they had harvested at sundown. In this case, the circuit went ahead. In this case, this was the Sixth Circuit. The circuit reversed and remanded based on the statements that came in. An excellent case when we're talking about in furtherance of the conspiracy, something that it is the bane of our existence, that is widely exploited and courts let in on a daily basis. But again, this is a nice case to go ahead and keep the government in check. Now, so as we're wrapping up here and we're getting to the 2-hour mark, just to review where we're at with things, today we covered boxes 1 through 3. That is, we talked about a hearsay definition. We talked about what is declarant, that the statement has to be made at a court. We talked about what is a statement, and we talked about the statement has to be offered for its truth, for it to actually be hearsay. Then we talked about hearsay exclusions under Rule 801. This is categorically not hearsay. And again, we talked about such things as prior consistent statements made under oath at a prior proceeding, prior consistent statements, and also statements of identification. And then in addition to that, we talked about opposing party statements, which included personal statements and also included very saliently statements made by co-conspirators. So then next session, we'll actually get into the meat of the exceptions. We're not going to cover, obviously, every exception under the rule, but we want to cover the marquee exceptions that impact us as criminal defense lawyers the most. And then on top of that, we're going to go ahead and also talk about how to challenge the hearsay declarant. The prosecution brings in hearsay. how do we get to challenge that if it's hearsay where the defendant didn't even testify? And of course, next time we're going to be talking about hearsay under 803 and 804. That is hearsay where it doesn't matter whether the defendant is on the stand or not, the declarant is on the stand or not, and as well as those exceptions that require that the declarant be unavailable. And then finally, we're going to talk about the intersection of hearsay and the confrontation clause. So once again, I am extremely thankful that you spent this time with me. I hope this was of some assistance. And should you have any questions or would like to go ahead and brainstorm an evidence issue, a hearsay issue, or any other kind of evidence issue, please don't hesitate to go ahead and contact me. And again, I look forward to seeing you for the second part of the presentation, that being the discussion on the hearsay exceptions. And with that, thank you very much. It's been a pleasure to be with you, and I hope to see you next presentation.